One of the most common things parents say is, "But I'm the mother," or "But I'm the father." And honestly, I understand why they say that. When you're raising a child, making sacrifices, caring for them every day, it feels obvious that your role as a parent should count for something. And it does. But when a family dispute crosses international borders, the law often starts with a very different question. Not, who loves the child more? Not, who is the better parent? But, which country has the legal authority to decide? And that is where many parents get the shock of their lives. Welcome back to Asking the Expert, understanding family law, child protection and child well-being. I'm Arielle, lawyer, researcher and mother. Through personal and professional experience, I've learned that what feels like common sense is not always how the law sees a situation. Today, I want to explain why. Imagine this. Your child has lived with you for years. You take them to school, attend medical appointments, and know what keeps them awake at night. Then suddenly, you're told that another country may have the power to decide your child's future. Most parents react with disbelief. But international family law isn't only concerned with who loves a child, it is also concerned with stability, consistency, and legal process. When courts look at international family disputes, they often ask, where is this child's life centered? Not where they are currently staying. Not where one parent wants them to live, but where their ordinary life exists, their school, their doctors, their friends, and their day-to-day routine. Think of it this way, if someone wanted to understand your child's life, which country would they look at? That question is extremely important. Imagine a father agrees that his child can travel abroad with the mother during school holidays. Everyone agrees it will be temporary. The child travels. Weeks pass, then months. The child does not return. The mother genuinely believes the child is happier where they are. From her perspective, staying may seem reasonable. But the court may ask, where was the child's home before the trip? What was actually agreed? Notice something important. The court is not starting with emotion, it is starting with facts. This is where verbal agreements create huge problems. Parents often tell me, we talked about it. We had an understanding. We agreed verbally. The problem is that people often remember conversations differently. Months later, one parent may say, I agreed to a holiday. The other says, no, you agreed to relocation. Now there is a dispute. Reconstructing conversations from memory can become extremely stressful and expensive. Clear written agreements can make a significant difference. I understand how frightening this can feel. Parents act from love and concern, then discover rules they never knew existed. That doesn't make them bad parents. It makes them parents who didn't realize how complicated cross-border family disputes can become. So what should every parent remember? Lesson number 1. Travel is not the same thing as relocation. A holiday abroad and a permanent move are very different in the eyes of the law. Lesson number 2. Never rely entirely on verbal agreements for international travel. Clear records matter. Lesson number 3. Courts often focus on stability before competing preferences. They ask, what arrangement protects continuity for the child? Remember, common sense and legal reality are not always the same thing. Understanding that difference can change everything. I'm Arielle, and this is Asking the Expert. Join me in the next episode as we explore why the law doesn't always automatically agree with your intent. Understanding the law can change lives. This content is for educational purposes only. Every case depends on its own facts and circumstances.